Civil Procedure Code Practice Questions Session 15. In this session, we will discuss the questions that may be asked in Judicial Services examination. We help the students in preparation of Judicial Services examination through WhatsApp. If you want to receive regular updates, please send us your mobile number through WhatsApp on 8199898985. Question number 351. Which of the following statements is correct? Option A. An order under Order 9, Rule 6 can be set aside under Rule 7. This is correct statement. Option B. An application for restoration of the suit under Order 9, Rule 4 or Rule 9 must be made within 30 days of dismissal. This is also correct statement. So, answer is option C. Option C is the answer. Question number 352. Mark the incorrect statement in relation to an ex parte decree. Option A. An ex parte decree is a decree passed in the absence of the defendant. This is correct statement. Option B. An ex parte decree is neither null and void nor inoperative but is merely voidable. This is also correct statement. Option C. An ex parte decree may be passed either at the first hearing or at an adjourned hearing. This is also correct statement. Option D. An ex parte decree can be set aside under Order 9, Rule 12. This is a incorrect statement. So answer is option D. Option D is the answer. Question number 353. Which of the following remedies is not available to set aside an ex parte decree? Option A. Appeal under Section 96 Subclause 2. Option B. Review under Section 114 and Order 47. Option C. Application under Order 9, Rule 13. Option D. Suit in all cases. Suit in all cases is not the following remedies available to set aside an ex parte decree. Answer is option D. Option D is the answer. Question number 354. Under Order 9, Rule 13, an ex parte decree can be set aside on the ground of Option A, someone not duly served. Option B, defendant was prevented by any sufficient cause from appearing. Option C, both A and B. Option D, irregularity in service of summons where the defendant had adequate notice of the date of hearing of the suit. So answer is option C. Option C is the answer. Question number 355. Which of the following is a sufficient cause for the absence of the party at the hearing of the suit? Option A, bona fide mistake as to the date of hearing. Option B, inability on account of illness or accident. Option C, fraud of the opposite party. So answer is option D. Option D is the answer. Question number 356. Mark the incorrect statement. Option A, in deciding the restoration application for setting aside an ex parte decree, the merits of the case should be taken into account. This is incorrect statement. Option B, as a general rule, the court will set aside the decree only against such defendant or defendants who had made an application. This is correct statement. Where the decree is of such a nature that it cannot be set aside as against such defendant only, the court may set it aside against the other defendants also. This is also correct statement. No ex parte decree can be set aside without notice to the opposite party. This is also correct statement. So answer is option A. Option A is the answer. Question number 357. A sues B and C on a promissory note. An ex parte decree is passed against both. B alone applies to set aside the decree and shows sufficient cause for his absence. Option A, the decree must be set aside against C also. Option B, the decree cannot be set aside against C. Option C, depends on the court's discretion. Option D, the decree can be set aside against C also if he shows sufficient cause for his absence. Answer is option A. The decree must be set aside against C also. So answer is option A. Question number 358. An application under Order 9, Rule 13 can be made within. Option A, 30 days from the date of the decree. Option B, 60 days from the date of the decree. Option C, 90 days from the date of the decree. Option D, 120 days from the date of the decree. An application under Order 9, Rule 13 can be made within 30 days from the date of the decree. So answer is option A. Option A is the answer. Question number 359. Where the appellant has withdrawn the appeal preferred against a decree passed ex parte, the application under Order 9, Rule 13 shall be option A rejected, option B returned, option C maintainable, option D referred for opinion to the appellate court. Where the appellant has withdrawn the appeal preferred against a decree passed ex parte, the application under Order 9, Rule 13 shall be maintainable. So answer is option C. Application is maintainable. Question number 360. Which of the following is not an effect of setting aside an ex parte decree? Option A, restoration of suit. Option B, commencement of trial de novo. Option C, evidence that had been recorded in the ex parte proceedings is taken into account. Option D, none of the above. Which of the following is not an effect of setting aside an ex parte decree? Evidence that had been recorded in the ex parte proceedings is taken into account is not an effect of setting aside an ex parte decree. So answer is option C. Question number 361. Mark the incorrect matching. Option A, first stage in the suit, presentation of a plaint. Option B, second stage in the suit, filing of the written statement. Option C, third stage in the suit, framing and settlement of issues. Option D, none of the above. Option A, first stage in the suit, presentation of a plaint. Correct matching. Option B, second stage in the suit, filing of the written statement. Correct matching. Option C, third stage in the suit, framing and settlement of issues. Correct matching. So answer is option D. Option D is the answer. Question number 362. The first day of hearing of the suit implies option A, the day on which the court apply its mind to the case for framing issues. Option B, the day on which the court apply its mind to the case for taking evidence. Answer is option C. Option C is the answer. Question number 363. Which order provides for examination of parties by the court? Option A, Order 9. Option B, Order 10. Option C, Order 12. Option D, Order 15. Answer is Order 10. Order 10 provides for examination of parties by the court? Answer is option B. Question number 364. The court shall, at the first hearing of the suit, option A, record the admission and denials. Option B, direct the parties to opt for one of the modes of alternate dispute resolution specified in 89 of the code. So answer is option C. Option C is the answer. Question number 365. Order 10, Rule 4 provides that if a pleader refuses or is unable to answer any material question relating to the suit, which the court is of the opinion that the party whom he represents ought to answer. Option A, the court may postpone the hearing to a day not later than 7 days from the date of first hearing. Option B, the court may direct such party to appear in person on a day not later than 7 days from the date of first hearing. So answer is option C. Option C is the answer. Question number 366. Which order deals with the settlement of issues? Option A, Order 11. Option B, Order 12. Option C, Order 13. Option D, Order 14. Order 14 deals with the settlement of issues. So answer is option D. Option D is the answer. Question number 367. Issue. Option A, issue are the rival contentions of the parties based on their pleadings. Option B, issue are the lamppost which enlightens the parties to the proceedings, the trial court, and even the appellate court. Option C, issue guide the parties in the matter of leading evidence. So answer is option D. Option D is the answer. Question number 368. Under Order 14, Rule 1, in a suit, issues are framed in respect of: Option A, question of facts. Option B, question of law. Option C, mixed question of fact and law. So answer is option D. Under Order 14, Rule 1, in a suit, issues are framed in respect of question of facts, questions of law, mixed questions of fact and law. So answer is option D. Option D is the answer. Question number 369. Issues must be confined to: Option A, facta probanda. Option B, facta probantia. Option C, both A and B issues must be confined to facta probanda. So answer is option D. Option D is the answer. Question number 370. The duty to frame proper issues rests primarily on option A, the parties, option B, pleaders of the parties, option C, the court, option D, the plaintiff. The duty to frame proper issues rests primarily on the court. Answer is option C. Question number 371. Mark the incorrect statement. Option A. At the first hearing of the suit, the court must frame and record the issues on which the correct decision of the case appears to depend. This is a correct statement. Option B. The court is not required to frame issues where the defendant at the first hearing makes no defense. This is also correct statement. Option C. The court can refuse to decide the point on which an issue has been framed and evidence led, but the point involved is not mentioned in the pleadings. This is a incorrect statement. Option D. The court should not frame an issue which does not arise on the pleadings. This is also correct statement. So answer is option C. Option C is the answer. Question number 372. Issues of law can be tried as preliminary issues under Order 14, Rule 2 and have to be determined first. Such issues relate to option A, court's jurisdiction, option B, a bar to the suit created by any law. So answer is option C. Option C is the answer. Question number 373. The material from which the court framed the issues is option A, allegations made on oath by the parties or their pleaders. Option B, allegations made in the pleadings or in answer to interrogatories. Option C, documents produced by the parties. So answer is option D. Option D is the answer. Question number 374. Mark the incorrect statement. Option A. The court may examine witnesses and documents not produced in the suit before framing issues, for that it may adjourn the framing of issues up to 7 days. This is correct statement. Option B. The court may at any time before passing a decree strike out wrongly framed issues or amend the issues or frame additional issues. This is also correct statement. Option C. Mere omission to frame an issue is not necessarily fatal to the suit. This is also correct statement. Option D. The parties may frame by consent special issues in the suit. This is a incorrect statement. So answer is option D. Option D is the answer. Question number 375. Additional issues may be framed under option A, Order 14, Rule 3. Option B, Order 14, Rule 4. Option C, Order 14, Rule 5. Option D, Order 14, Rule 6. Additional issues may be framed under Order 14, Rule 5. Answer is option C. We help the students in preparation of judicial services examination through WhatsApp. If you want to receive regular updates, please send us your mobile number through WhatsApp on 8199898985. Please feel free to contact us at legalbuddy@gmail.com. Thank you.